Right now, we're going to be talking about mediation in personal injury cases. I've been to hundreds of these mediations. I practice personal injury law in California. So I'm going to be talking to you about what mediation is and what to expect. First of all, a mediation is an informal process where the parties, the defendant, the plaintiff, their attorneys, they get together, try to resolve the case. When I say informal, what I mean is it's not in a court. It's not under oath. It's usually in an office someplace. There's a retired judge or a lawyer that's acting as a mediator. He or she is supposed to be independent. And they go back and forth between the parties trying to get the case resolved. If you're not represented by an attorney, you're going to have to be doing a lot of the talking. But if you have an attorney, your attorney is going to be talking on your behalf. In my cases, we submit a brief, which is basically a paper or a document outlining the case, what's happened in the case, the damages. Sometimes we attach evidence and exhibits like medical records, photos, police report. The defense will submit something also. So the mediator has an idea of what the case is about and what the issues are, and maybe understands why the case is resolving. Usually the people at the mediation, there has to be decision makers. So if you're the injured person, typically you've got to be at the mediation because the case can't resolve unless you approve it. Likewise, usually the defendant or an insurance company representative is at the mediation because they're the one that needs to approve the settlement to make sure it gets done. You don't want a situation where the decision maker is not present and you're negotiating and you think you've got a case resolved, and then it turns out the decision maker, whoever that person is not there and decides not to approve it after you've been going back and forth for hours. Mediations can vary in length. They can be as short as an hour or even shorter. Typically, the mediations I see in my cases are anywhere from 4 hours to 7 hours. They could be multi-day mediations. Usually for a straightforward injury case, it could just be a couple hours, maybe 4 hours. Oftentimes now, these mediations are done on Zoom in California, which means that you can be home or you can be somewhere comfortable, have a Zoom connection, participate in the mediation that way while the mediator goes back and forth. Sometimes the mediator will want to meet with your lawyer separately from you. And the reason that they do that is because sometimes the mediator is going to be sharing information they learned from the other side. It could be upsetting. They could be calling out your credibility, or they could be questioning things. And they don't want you as a participant in the mediation to be getting upset about it, because sometimes your emotions can get in the way of trying to get the case resolved. So they'll communicate that to your lawyer, and your lawyer can explain things that are sensitive to you without you necessarily spinning out of control and the whole mediation gets messed up. If the case doesn't resolve at mediation, which can happen, in fact, I would say maybe half my cases don't resolve at mediation. Oftentimes there's a discussion that happens during the mediation that can help facilitate the case getting resolved later. So even though it doesn't get resolved at the mediation, maybe a month, 2 months later, 3 months later, because those discussions have happened, maybe there's things the other side needs in order to get the case resolved, and then it could ultimately still settle. But you are not required to settle the case at the mediation. If it doesn't settle at the mediation, you just keep moving forward, usually to a trial date. What I tell people about mediations is that it's one of the few opportunities that you have to have control over your case. But if the case doesn't settle, often in my cases, you're going to go to a jury trial. That's going to be 12 random people deciding the fate of your case. And we know from just living in the United States, 12 random people, all those people can have very different opinions, can have different life experiences, different expectations. They might be against the jury system. They might be against the idea of getting money for pain and suffering. So if you can get to a number that's reasonable, that you can have some control over, sometimes it does make sense to get the case resolved and get some closure. Oftentimes, people don't realize that going to a jury trial is only another step in the process. Even if you win your case, that's just a piece of paper. It's a judgment. You still have to collect it. There could be appeals. There could be post-trial motions. So even though you go to trial and you win, it could be a while before you get paid, and there could still be ongoing negotiations. So that's why mediations can be very productive and helpful.